Welcome, Zakeera, Dr. Zakeera Docrat. So you've been in several interviews, this last couple of months, talking about various things about court and language, and you've written articles as well. So just to get everybody up to speed, the Supreme Court of Appeal, President Mandisa Maya, made a call for the development of an informed language policy for the courts that would facilitate the use of all our official languages in the legal sector during the interview for the role of Chief Justice by the JSC, or Judicial Services Commission. There was a focus on her judgment written in Xhosa once again during her interview for the role of Deputy Chief Justice of the JSC. We also saw it with the Senzo Meyiwa trial, which also further amplified that the use of English as the main language of justice may be an inadequate means of communication for many South Africans seeking justice in South African courts. Dr. Zakeera Docrat, you've spoken a lot about language equality. And so what does this mean in practice, and what does it mean for ordinary people and judges? Because I also saw that there was a particular judge that seemed to have a particular problem with Justice Maya's writing her judgment in Xhosa, and she felt it was a problem. What does language equality mean?
Siki, thank you very much for having me on this podcast, and good morning or good afternoon or good evening to everybody who's going to be viewing this, depending on where you are in the world. Language is complex. I think it depends where you are. Let me first say that, which side of the fence you're on. So if you're pro using one language only, specifically English, then obviously you'll see things differently. If you're pro using the indigenous languages, then you'll see things from the other perspective. But yes, the JSC process is also a complicated matter. Language doesn't feature at the JSC interviews. And when I say it doesn't feature, I mean, we hardly see commissioners asking potential candidates questions about language in terms of their competencies, how they view the use of languages other than English as part of the languages of record proceedings, writing judgments, and so forth. So, when we have these kind of breakthroughs, like with President Mandisa Maya, other candidates such as Advocate Thandi Norman and so forth, coming through and actually mentioning it themselves and saying, this is what I'm doing in terms of writing bilingually, encouraging other judges to use the indigenous languages and so forth. That is fantastic. That's when we as forensic linguists jump up and down and celebrate in a sense and say, wow, that's amazing. But that has to continuously happen with every candidate, asking them these types of questions. And I know from a constitutional perspective, and I don't know if the viewers watching this might know, but Section 174, which guides the appointment of our judges, doesn't really speak to or mention language. Language competencies as something that we need to, a factor that we need to take into account. It solely focuses on race and gender. And obviously for you and I, that's great. We are both Black females, and that's wonderful, and I fully support that. But I think, and it's my opinion, that language should be taken into account. Getting back to your question, it was very sad actually to see that Judge President Leo, who actually posed the question to Mandisa Maya and actually grilled her in a sense, said to her, but why did you choose to write a judgment bilingually?
That was a grill.
Yes, it was a grill. When it concerned AfriForum. Now you see, Siki, again, we got hung up on the politics. Instead of focusing on saying, Justice Maya, this is a positive that you've achieved, and how did you do it, and what were the strengths and the positives of doing this? or how can we improve and emulate this? What the commissioners got hung up on, or certain commissioners, was the fact that this was an AfriForum judgment, or concerned AfriForum as one of the applicants or respondents in the case, and that it concerned Afrikaans language speakers' language rights. Now, again, we're creating this othering in terms, and when I say othering, that's when we divide our languages. We're saying that the Afrikaans speakers don't belong in the group of the African languages, and that's a debate on its own, okay? But what we're creating
that's a debate that I think highlights a lot of just the language issues of our countries, and I think possibly this language equality that you focus on.
Yes, so that gets back to language equality, okay? So as soon as we start creating this othering, okay, and we place certain languages in certain boxes, then we are excluding languages, okay, on the basis of our racial past, on the basis of our current political landscape, and so forth. But what I mean by creating linguistic equality is where we see all our languages, all 11 official languages, including English, okay, despite its past, as equal, where we take our indigenous languages, our African languages, and we place them equally alongside English and Afrikaans, who have both enjoyed, and we must be honest with that, both enjoyed a superior position over our African languages for the past however many years, hundreds of years. So what we want to do is we want to say, we don't want to remove English. We don't want to remove Afrikaans, which unfortunately has already been removed. We want to take the African languages, we want to place them equally alongside English and Afrikaans. And when I say by placing them equally alongside, I mean by using them equally within courtroom discourse, using them broadly within the legal system, not just within writing of judgments and hearing proceedings and recording in these languages.
So what would this mean in practice? So it appears as if we need a new policy. Is that correct?
Yeah, policy and legislation are the issue, okay? Because the current legislative and policy frameworks, and I don't want to get hung up and bore people with this, but the current legislative and policy frameworks exclude the use of the African languages for courtroom use. And specifically the 2017 monolingual language of policy record, that is an actual directive that was taken by the heads of court in 2017 under the former Chief Justice to say, let's remove Afrikaans on the basis of transformation. Now, we know that that's not transformative, removing one language in favor of another. You're creating a hegemonic position for English to enjoy. And you're disadvantaging, obviously, the African languages even further because you're moving from bilingualism to monolingualism instead of moving to multilingualism. Lots of isms there. So that was the first, that's the major issue, is that policy directive. Now, it's my argument that that policy directive was not permitted to be taken by the heads of court because they don't have the legislative authority. And when we get nitty gritty and we go back to the legislation, the Superior Courts Act, and what it says there in chapter 3, specifically section 8, it says that the heads of court don't have the power to decide the language of record. So it's actually a ministerial decision that should be taken in consultation with the judiciary and the heads of court to say, let's formulate a language policy, but that hasn't happened.
And
so,
sorry, Dr. Zane. So whose responsibility is it then? Is it the public? Is it the legal practitioners? Who should press the Minister of Justice? And I can imagine that somebody like Minister Lamola, that I can't imagine opposing this. I imagine that he comes from a younger generation and so might be more connected. So whose responsibility is it to push the Ministry of Justice to ensure that this policy is very much a part of of policy making and is kind of distributed in every court and known by even people? Because I know when I posted this initially on social media, people responded, and there was someone who said they have been denied a language interpreter in a court situation where they needed to use their mother tongue and they were denied. And so that to me also seems to impede on 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 justice itself, on people being able to access justice, because if you cannot communicate in your language.
Yes. Yeah, it's very complicated, Siki. But I think it's our collective responsibility. You're asking me whose responsibility it is to put pressure on the Minister of Justice. It's our collective responsibility as speakers of the African languages. I always urge the speakers of the African languages to say, speak up, it's your languages, you need to fight for them. It's also our responsibility as forensic and legal linguists, as members of the Indigenous Languages Action Forum, to constantly be vocal about these issues, to ensure that we get media attention, to say, look, this is the research we've conducted, this is the positives of implementing and using languages other than English. Why are you not doing it? Can you give us reasons, and so forth? So I think it's going to take a massive push, not just from one person or 10 people, from the entire country, and that's what we need. But in saying that, you know very well that at the same time, parallel to putting pressure on ministers and so forth, we need to convince ordinary South Africans as well to say, why is it important to use your language in courts? So, because some people don't see the importance of it as well. And to get back to your question of interpretation, that's very worrying to hear what a user on social media said. They do have a right to interpretation. That's a constitutional guarantee in terms of Section 35(3)(k). So whenever you cannot speak English or understand English, interpreter will be provided to you at the state's expense. And that's, as I said, a constitutional guarantee. But Siki, I must say, that's only in criminal cases. And this is why a monolingual language of record policy is so dangerous. And I use the word dangerous because it excludes people, dangerously so, in the civil system. So let's give a scenario. If you're appearing in a civil trial, or let's be really dramatic, and unfortunately these are the situations that exist. Your house is about to be taken away from you by the bank. You appear in court, okay, it's a summary judgment, let's say, and you need to give reasons why it shouldn't be attached and sold. And you cannot speak English, you cannot understand English, or you have a minimal competency in English. You are not provided with an interpreter at the state's expense. So what happens to you in those cases? These are the people that are slipping through the cracks, and that the judiciary, heads of court, and the ministry need to take notice of. And these are the people we need to focus on as well, because we always focus on the criminal justice system, and yes, that's important, but we also need to say what is happening in the civil system. These people are not being heard. Their voices are going unheard. The courts cannot hear them, and they cannot hear the court.
That's really good. One of the challenges from Judge Maya's, when she was being interviewed for Grilled, to be specific, one of the points was that if she writes her judgment in Xhosa, for example, the question was sort of suggesting that it becomes exclusive to the speakers who can only speak that language. And so it seemed as though the accusation was that the interpretation, it then limits who can read it, and therefore the interpretation of the judgment when it is being translated to another language. So the judge that was questioning her seemed to suggest that that's why it's a problem.
I hear you. I did watch that interview, and I did take note of what was being said. But you know, Siki, you'll constantly have people from all sectors, whether it be within the judiciary or outside, even members of the public, disagreeing with our stance and what President Mandisa Maya is saying and doing, in fact. And this goes back to what I was saying at the beginning when we started this podcast. You know, it depends which side of the fence you're on and what your viewpoint is. I think it's a pathetically weak argument to make and to ask such a silly question, because the judgment was written bilingually, okay? So the English appeared on one side and the isiXhosa appeared on the other side. So there was no possible way in which any speakers could be excluded to say that this judgment was written solely in isiXhosa because she wrote it bilingually. Okay, so she conformed with a policy to say that judgments be written in English. She just added to it to put the isiXhosa translation there, which was obviously her original. So when you're writing bilingually, nobody's being excluded. You equating the African language or Afrikaans, which either one you're using, alongside English, and that goes back to language equality. And when we do that, when we use these languages, we are using them for scientific purposes. So in fact, she at the same time is developing isiXhosa and the terminology.
It's so true.
It's okay. So eventually, coming from the judiciary, we will also have a corpus which we can rely on, other judges can rely on in terms of terminology, because that's also an excuse that's used most often to say that the African languages are not fully developed for scientific use. They're not fully intellectualized. So we don't have terminology development, so we can't use them in courts. So with judges writing now bilingually, this will create a corpus, and this is something as forensic and legal linguists and even lexicographers can come on board and say, look, let's create a corpus now in partnership with the judiciary. This corpus be shared as it develops within the judiciary, amongst the judges, amongst the magistrates, to say, here's the corpus, you contributed as you're writing your judgments, and you can use the terminology that's coming out of it. So you're actually developing the languages besides just you promoting them.
Yes.
And that really feeds back to what our constitution says about promotion, use, and development. So all three of those things are happening simultaneously, which is fantastic. So you see, Siki, those are the positives that should have been focused on. But it goes back, and I'm going to be criticized for this, it goes back to the issue as well, I think, of who these commissioners are sitting on the JSC asking these questions. Because these people who pose these questions, do they have any language backgrounds, formal language backgrounds, to be asking her this? Another positive, and I'm sure you picked up on this, is that President Maya said, she secured the services of a legal translator. Now, that also speaks to the opportunity for creating employment for our student forensic linguists, our legal translation students that are coming through the system that we are graduating. So, it creates a whole other arena, in a sense, within the legal system to say, here's an employment opportunity as well that the ministry could possibly exploit. But
That
again, those questions were not followed up on.
That's so good, Zakeera Docrat. This was actually going to be my last point that I wanted us to talk about, because I was thinking, what's the link between, are there any economic opportunities? What are the costs economically? Because you know this very well, that there's always when it comes to indigenous languages, the first thing people say is we don't have the money. Suddenly there's no money when it comes to any use of indigenous language, and at the same time they say, okay, the language is not developed and we don't have money to develop it, and therefore we must just use single language. So what are you just highlighted, for example, this legal translation, that because it's a specific field, it can't really be translated by just any translator. Is that correct? So
that's correct.
So it actually means, does this also mean, for example, that there is a new discipline within universities itself, within South African universities, that would be developed, that specifies or specializes in indigenous languages or language translations and the legal field? What are the implications economically with employment, with new disciplines that will become formalized? What are the opportunities?
Okay, so the first thing is that obviously the employment opportunities would be there. In terms of these people being specialized, yes, you would have to be, because this is also an issue with interpretation, Siki, because our interpreters sometimes lack formal qualifications, okay?
That's
And
true.
it's all very well to say that I'm an interpreter, but are you a legal interpreter? Because you remember, you're interpreting within a legal discipline, okay? So you need to have the terminology and the skill within a legal system and sector, as well as the linguistic qualifications. So that is subsumed. That's why I talk about legal translation and legal interpreting. It's
Just
subsumed under.
a little point on that.
Yes.
Sorry, Dr. You
Yeah.
actually mentioned that because I don't know if you remember the beginning of the year where after the burning of Parliament, I watched some of the court proceedings there, and there were issues, with the language translation, so that because one of the legal practitioners understood isiXhosa, found that the interpreter was misinterpreting. So you're talking about, that also, because I also picked it up. I was concerned. There were issues there with that interpretation. So you talk,
Definitely, Siki.
yeah.
So, it also then, there are several issues now we are raising, but let me stick to the interpretation, then I will address the legal, then I will address the legal practitioners as well. With the interpreters and the translators, they will have to graduate under the field or the discipline of forensic linguistics, legal linguistics, okay? Which I'm currently involved with the heading up of in South Africa.
Wow.
It's fully fledged overseas, okay?
Wow.
So this is new to South Africa, and this is why Siki constantly, and you would have picked up on this in media interviews over the last few months and years, in fact, I've constantly invited and encouraged ministries, specific ministries of justice and police, to collaborate with us. Because as I said, we can't be seen as individuals working in our little spaces on our little boxes. My research and that of my students and our colleagues and all doesn't exist in a vacuum. The research by members of the Indigenous Languages Action Forum doesn't exist in a vacuum and should never just be published and filed away. We should take that research and say, look, how must it be implemented? That is my view, okay? That's how I see research. How does it make a difference to society and contribute? So I think there's a need for a partnership there and some sort of meaningful engagement between academics, researchers, and government organizations, government departments, and the judiciary, obviously. So that would be the first thing, to get the training of our interpreters, our current interpreters, undergo, okay, to make sure that the people in our system, because we don't want to fire these people, we want to retain them, we want to build on their skill. Many of them have a lot of experience, Siki, but don't have formal qualifications. Now, you never want to throw the experience out, because then you're throwing the baby with the bathwater out. That's not what we want to do.
That's true.
So it would be up to us, in partnership with all these different stakeholders, to say, let us train your interpreters. Whether we do that province by province, we could work that out, okay? That's the first thing. The second thing, as we are doing that, we feed the system with the graduates coming through the system, graduating with forensic and legal linguistics with a speciality in translation and interpretation, who then feed the system, who work in the Department of Justice and in courts and so forth, and assist. Because there will always be a need, Siki, for interpretation in our courts, whether we have all 11 languages used in our courts on a provincial basis or not. There will be a need for translation and interpretation services, okay? So that's the first issue. We don't want to threaten anybody's job. We want to create employment, not take away.
That's good.
The second thing is that you picked up on the legal practitioners actually interpreting or picking up on issues when interpreters are failing to interpret correctly. And that happens in many instances that are not reported, where a legal practitioner or even a judge will say, but that's not what the witness said. Okay, you got it wrong. So in those instances, we see some legal practitioners saying, this is actually what the witness said. But we know that the legal practitioner can't act as an interpreter, neither can the judicial officer. Then we are met with delays of verifying whether that's what the interpreter did say and whether it was correct and so forth. So again, we're seeing delays due to competency, due to qualifications. Okay. The positive there is that if a legal practitioner can speak an African language or Afrikaans, that's a positive in a courtroom situation where the witnesses don't speak English and might speak the practitioner's language. Okay.
Yes.
So again, it speaks to the importance of our legal practitioners and our LLB graduates graduating with degrees that include a language qualification. And this was made many, many years ago, in fact, by the Parliamentary Committee to suggest, I think it was 2017, but I speak under correction, to say, let our LLB graduates graduate with an African language, regardless of which institution they go to. So you have some sort of multilingual competency when you leave university. Remember, you're going to exist in a multilingual courtroom. You're not going to exist in an English courtroom. But that issue was eventually mooted. And it lost momentum as usual with many things we do in South Africa. We jump up and down about something, and then slowly the momentum is lost. So that's also a positive. It's also a positive to say, let's train the current cohort of legal practitioners in terms of vocational specific courses in various provinces. To say, again, with forensic and legal linguists, let us train you linguistically. And I don't know, Siki, if you picked up on the Meyiwa case and the language complexities and sensitivities that actually happen there with legal practitioners and judicial officers.
Yes.
So, you know, it again spoke to the fact that English is not a practical language, might not be a practical language in all circumstances. And I think this is what the judiciary and people who are pro using English only seem to say, that it's practical in the circumstances. Okay, in the case of State versus Gordon, let me tell the viewers that the judge, who was an African language speaker, mother tongue speaker, said it's practical to use English because everybody who exists in the legal system understands English and speaks English. Now, that's not true, Siki.
It's not true.
It's not true, because you haven't tested every single person in the entire legal system's English proficiency. Look, you and I might understand English and speak English, but we have different levels of competency. We have different levels of competency in isiXhosa. We have different levels of competency in Sesotho. So, you know, until you start doing that, then you can fully say everybody speaks English and everybody understands English. Only 9.6% of the population speak and understand English at mother tongue proficiency. So I think that was a misplaced and misguided comment in a judgment to exist. Well, I don't know if I answered your question.
I think you did. I think for me, with this conversation, one of the things that you mentioned was the need to bring awareness to, awareness to the public as well as the various stakeholders, because the language, this movement, because it is a movement of Indigenous languages, is something that does affect anyone who'll ever use South African courts, in a sense, because as you say, what if the lawyer or the judge, that their competency is different, their English competency. And I think we also saw with the Meyiwa case, we saw with the policeman who was being, who they had to find Sesotho interpreter, where they had assumed that he speaks English, he will understand English, but he himself needed an interpreter, So I think every day it's becoming proven that we do need competency in Indigenous languages, and it's something that should be a part of, I think it definitely needs to be a policy that's taken seriously. And I thought it was grievous to find out that some people have been denied interpretation in court, which is then they denied justice in a sense, because if they don't understand what's being said, what's going to happen? And what I learned a lot more about, this forensic language that I didn't understand. I heard about it before. I had no idea what it meant. And I really didn't see how it could affect my life. I just didn't understand. It just seemed like out there, and because I don't have any relationship with the legal field. and no expertise in it. So I honestly didn't understand it. But with what's happened in our country and the indigenous languages in courts has been really highlighted. So you get to see it in practice, and you see all the holes in live, and you understand, oh, this is what it means. So I think this year has been a fantastic year for your work. And it's been wonderful that you have, you are prepared, and you know what you're doing, and you also sent a call out to the JSC in one of your interviews to assist them, which I hope they have reached out to you. So
I'm still waiting.
You're still waiting. So I'm just saying that, I think the awareness has been fantastic this year, and I think we're going to see more of it. And I'm really excited about your work, and I'm glad your work exists, because I think we'll be in real trouble because it's a huge gap. So thank you very much for your fantastic work. And you'll probably need to employ a lot more people in the days to come. Because there's a whole country to cover.
We hope that we can continue to, grow the field and make a positive contribution to ordinary people's lives, ordinary South Africans, fellow South Africans who are accessing the justice system. I think we always need to see it from somebody else's perspective. Just because we have good access to English and English is our mother tongue, doesn't mean the next person has the same ability and is fortunate enough to have had good access to English, and that shouldn't be seen as a benchmark of any sorts to accessing justice or achieving justice in any way. It should be accessible to the entire country, and the majority of our countries speak an African language, and that's a given fact, and we need to celebrate that. We need to welcome that and embrace that. And I think as soon as we start to do that as a country, half our battle will be won, and we can start focusing on the positive seeking and not get hung up on how much money. I mean, it's always going to cost us money, no matter what we do. But I think if we have the willpower and we are committed to ensuring the elevation and the use of our African languages on an equal basis alongside English and Afrikaans, then money should not be a factor. We can find money somewhere. I know that there was a study conducted, I think back in 2004, that found if we take 2%, obviously those figures might have changed by now, if we take 2% from each ministry's budget, we could start to use languages other than English in the legal system. So that's really minor. And it's not to say that we expect tomorrow for a linguistically transformed legal system, but we need to start somewhere. So in the next 10 years, we are not having these conversations. We are having a conversation to say, what are the positives that have come over the last 10 years, and what have we achieved, and what are the next steps that we are taking? Thank you very much for the opportunity today, and I hope we can have a follow-up discussion, because each of these issues need to be fleshed out in further detail, I feel.
Yes. Thank you so much, and what a great start. Thank you so much for your time, and thank you for your work, and thank you to your team as well. It is a great service for our country. Thank you very much.
I really appreciate your sentiments. Thank you very much.
All right. Thank you. Okay. Bye.
Bye-bye.